Welcome to Call to the Bar, International Law Over Drinks, a series of informal conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we're speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Ntina Tzouvala. I am an associate professor at UNSW Sydney, and today I'm joined by Dr. Julia Dehm and Dr. Cristy Clark to discuss the recently announced plan of Australia regarding its emission reduction targets for 2035 from an international law perspective. To introduce our wonderful guest, Dr. Julia Dehm is an associate professor and an ARC-DECRA fellow at La Trobe School of Law. Her research addresses international and domestic climate change and environmental law, natural resource government, and questions of human rights, economic inequality, and social justice. Her first monograph was Reconsidering Red, Authority, Power, and Law in the Greek Economy. It was published by Cambridge University Press in 2021. And she's also the co-editor, together with Nicole Graham and Zoe Ney, of Becoming a Climate Conscious Lawyer, Climate Change and the Australian Legal System. We will drop a link to this volume, not least because it is an open access resource. Dr. Cristy Clark is an associate professor at the University of Canberra School of Law. Her research focuses on the intersection of human rights and the environment, including issues of legal geography, Indigenous rights, and the commons. She co-authored a book entitled The Lawful Forest, which is such a wonderful title, A Critical History of Property, Protest, and Special Justice, that was published by Edinburgh University Press. And also very recently, in June 2025, her second book came out entitled Legal Geographies of Water, The Spaces, Places, and Narratives of Human-Water Relations, which was published by Routledge. So as it is very obvious, they're both very well placed for this conversation. But before I get into the substance of the discussion, I must ask the customary question of this podcast, which is, Julia, Cristy, what is your drink of choice?
Well, in honor of this podcast, I've just poured myself a little glass of whiskey, and the title of the bottle is Sovereign. So I thought that was
Excellent.
appropriate for an internationally law-themed discussion. I've also got some
Absolutely.
sparkling water.
Excellent.
And I have a cup of tea with oat milk because it's 7 a.m.
Yes. Cristy is joining us from the UK, and we're very grateful. I am just drinking water, but now that Julia mentioned whiskey, maybe I'll pop out at some point and have myself one. Okay, so you're both new to our podcast, and we're always very curious to hear how people ended up working on international law. What was your life and career path that led you to international law?
Yeah, so after fleeing from a job in corporate law, which was in environment and planning, I did a master's in international social development, and I kind of completed a mini thesis project on the rights to food, health, and water. And one of the examiners of my paper commented, "You may struggle to find an NGO whose approach you agree with in relation to development." So maybe it was partly this caution, but it was mostly just I got really obsessed with the issues that I was looking at. And so I enrolled in a PhD at the Australian Human Rights Centre with UNSW Law, Dina. And it ended up being focused on the emerging international human right to water. I was really interested in how the right to water was being articulated and developed at the international level. It hadn't yet been recognised. And that kind of tension between how it was being articulated from below and through the institutional processes that were moving through the UN human rights system, and how these tensions were playing out in domestic contexts. My particular interest was the impact of neoliberal water governance frameworks on people's access to water, like privatisation, corporatisation, particularly in urban poor communities. So I did my fieldwork in Manila and Soweto. Since my PhD, I've ended up focusing more broadly on environmental rights and climate justice, but water does continue to be a big issue for me.
That is extremely interesting. And I think many will sympathize with the obsession of, oh, well, I tended to get obsessed with things. So doing a PhD seems like an appropriate step in my life. Julia?
So after my law degree, I completed my articles of clerkship, which is sort of a legal apprenticeship at Victoria Legal Aid, looking mostly in criminal law. But then at the end of that, I couldn't get admitted to practice because I was still on a community-based order myself for environmental activism. And then I decided to pursue further study instead. And then I started my PhD at Melbourne Law School, where I was looking at the international climate regime and particularly focusing on sort of critiquing the marketisation of international climate governance and focusing specifically on REDD+, reducing emissions from deforestation and forest degradation, which is a forest carbon-based offset scheme. Near the end of my PhD, I then did get admitted to legal practice and briefly went back to work at Victoria Legal Aid, but then took another sort of sharp turn of direction when I was offered a residential fellowship at the Institute for Global Law and Policy at Harvard Law School for a year. I then finished my PhD and subsequently completed a postdoc at the Rappaport Center for Human Rights and Justice at the University of Texas, where I was coordinating a multi-year project on human rights and economic inequality. Since 2017, I've been at La Trobe, where I sort of teach environment law and property law. In that time, I also acted as a consultant to the Special Rapporteur on the Right to Housing in 2022, looking at climate change and the right to housing. And in 2023, I was a member of the School of Social Science at the Institute for Advanced Studies at Princeton. And since 2014, I've been fortunate to be working on a DECRA project, which is focused on resource struggles and international law, looking at navigating different global transformations. And so, as well as that, I'm also doing a lot of work on questions of climate reparations and thinking about climate change law and time and temporality, as well as climate law and questions of racial capitalism.
Fabulous. Thank you both very much. I think our listeners will already have a sense of why we thought you will be a good duo for this discussion. And the discussion is that, as I said in the introduction, that very recently on the 18th of September 2025, Australia announced its 2035 emission target. I'm using the word target a little bit loosely here, aiming to reduce emissions by between 62 to 70% below the 2005 levels by 2035. And this is part of the government's stated goal of reaching net zero in 2050. And the government in its announcement maintained that this is a, quote, credible contribution to global efforts to keep global warming well below 2 degrees Celsius in comparison to the pre-industrial levels and keep 1.5 degrees Celsius within reach, that our listeners perhaps will recognize as a direct reference pretty much to the Paris Agreement. And I want to start here. I was really struck by this language, by this formulation, right? Because it seems to me clear that the formulation makes the 2 degrees Celsius the main goal, whereas the 1.5 is treated much more as a vague and aspirational, right? It used to be, quote unquote, within reach. Many things are within reach, but we never do them. And I was wondering, what do you guys make of this? And especially in light of the recent International Court of Justice advisory opinion on climate change and the way that it treated the Paris Agreement and the various goals enshrined in it.
Yeah, so as you know, you guys have had some great discussions about the advisory opinion. It did establish that 1.5 degrees is the primary target or the primary goal under the Paris Agreement based on, obligations under international law in relation to the climate system. And it explicitly rejected arguments that countries had made that they could aim anywhere between 1.5 and 2 degrees. Similarly, the court dismissed arguments that were also made that they were basically free to set whatever nationally determined contributions or NDCs that they chose. So these are essentially climate action plans submitted by countries under the Paris Agreement, and they outline how they intend to reduce emissions, but also how they intend to adapt to the impact of climate change. And the court clarified that these NDC emission reductions targets must represent adequate contributions reflecting highest possible ambition. So clearly this language appears quite inconsistent with Australia's decision to focus on 2 degrees as the main goal, and really seems to require a much more ambitious target than, they say 62 to 70, which let's face it, that's 62. Like, we all agree we can go past that and that would be a good idea. So the number at the end is just kind of, it's dressing. 62 is really not an ambitious target. A more adequate contribution reflecting the highest possible ambition, to use the court's language, most people would agree that should be closer to about 85%. And so we're really looking at a significant gap in ambition.
And also, and that's what I implied with my question, even a significant gap in its own target, right? That's why I said the word target is a little bit generous here. 62 to 70 is more than 10%. It's a 12% deviation, right? So I think it says a lot about the leeway that the Australian government is giving itself. And even on a very linguistic level, what is the highest possible ambition? Is it the 62 or is it the 70? Let alone your point about that neither would substantially be, but even before going to that discussion. Julia?
Yeah, basically just reiterate everything that Chrissy's already said. So one of the things that was really significant about the ICJ advisory opinion is that it really affirmed that now 1.5 degrees, not 2 degrees, is a scientific consensus target. And this is a target that we all need to be working towards. And so while the Paris Agreement presented the nationally determined contributions as very much nationally determined and called them contributions rather than commitments, the advisory opinion made clear that the content of these contributions is not entirely left up to countries, but rather they need to reflect, as we've already said, the highest possible ambition, and that these NDCs must collectively be capable of making an adequate contribution to the global effort to limit warming to 1.5 degrees Celsius. And this target of 62 to 70% reduction is not aligned with limiting warming to 2 degrees, let alone limiting warming to 1.5 degrees. A 1.5 degree aligned target would be, have to be above 81% or 85%, as we've already said, below 2005. Instead, analysis by the Climate Council shows that 65% target, which is sort of in the middle of this 62 to 70 range, is aligned with 2.4 degrees of global warming. It's really not. A 62% target could be aligned with above 2.4 degrees of warming. And just to say, this is not just a matter of numbers and figures. In the same week that Australia announced its NDC, it also put out our National Climate Risk Assessment, and it really showed what the real implications of exceeding 2 degrees are and the severe impacts that would be expected across all regions from extreme weather events and sea level rise in a 2 degree warmer world. So, for example, just to take one part of that analysis, in a 2 degree warmer world, 1.5 million people, or 17% of the coastal population, would then be living in high risk areas by 2050. So these figures have real consequences in terms of the future that we're creating. And the other thing I just want to stress too is that Australia should be making a fair share contribution towards the 1.5 degree target. And this idea of fair share is not a legal concept per se, and it's never clearly legally defined, even though the principle of common but different shared responsibility is obviously a linchpin of the international climate regime. And that states that countries with higher histories of sort of polluting activities or countries with greater capacity to take action due to their economic and technological capabilities should be making greater contributions. And I'd argue on both of those prongs in terms of historical responsibility and capacity, Australia needs to be taking a much greater, more ambitious leadership role in setting climate targets than we have done.
Fantastic, thank you. And I think one thing that comes out of your combined responses is basically the target is not in line with the Paris Agreement obligations as interpreted authoritatively by the ICJ. And I think there's something quite remarkable here, which is Australia was amongst the developed states that argued really passionately in front of the ICJ that the Paris Agreement had subsumed all other obligations under international law. We will get back to this, but it's not as if they're in compliance with the regime they're claiming is the only regime that is governing climate change, right? I think there is something there that makes that argument particularly annoying and concerning and enraging, which is they put so much effort to arguing that Paris is the only legal relevant legal regime, and then they put out an emissions target that is clearly in violations of the obligations of Paris. Okay, my second question is this. I wanted to ask you basically what does and doesn't count towards this reduction target, even if we take the more ambitious end of 70%. Will this be, let's say, Australia does manage to hit a 70% reduction in comparison to 2005? Will this be a real 70% decline in emissions, or is there any small print that we should be worried about?
So, I mean, there are several, but if we start with one, which is that Australia's approach to calculating emissions for the purposes, particularly of this net zero goal at the end, it's problematic because it doesn't include scope 3 emissions. And like this is probably very familiar territory for a lot of people, but some people it gets confusing. So really briefly, carbon emissions are roughly divided into 3 categories. Scope 1 emissions are direct emissions. So if I was a coal mine, for example, that's upsetting thought, but then the emissions generated on site by my mine, by the digging equipment or the trucks or the on-site generator, that's a scope 1 emission. Scope 2 emissions are related to inputs. So it might be things like the fuel that I bring in to run the trucks or things of that nature. They're kind of direct inputs into the project. And then finally, scope 3 emissions are those that are emitted elsewhere from things that we dig up here. So when my coal is shipped overseas and it's burnt and it pollutes and emits carbon, that's a scope 3 emission. And as a country that extracts a huge amount of fossil fuels sent overseas, scope 3 emissions are a really significant part of Australia's contribution to the climate crisis. But this target does not purport to count it in any way, shape or form. But I'll hand over to Julia.
Yeah, so just to elaborate on that a little bit more, like the real problem is that the NDC focuses just on our domestic emissions, and the real elephant in the room are our fossil fuel exports, which are not included in this target. The Australian government loves to say that Australia is responsible for only 1% of global emissions, but this is true only if you count just our domestic emissions. If you also count our exported emissions, in 2022, Australia's total fossil fuel carbon dioxide footprint was around 4.5% of global fossil fuel CO2 emissions. So it's huge. Our exports are much more significant than our domestic emissions. And there's been growing attention to the contribution that our exports make, particularly due to the work of the Australian Climate Accountability Project. They commissioned work last year that found that Australia was the 3rd largest fossil fuel exporter in 2021, trailing only Russia and the United States. But in terms of like global total greenhouse gas footprint from those exports, Australia ranked 2nd in 2021 if you count the in CO2 terms. So in 2022, Australia accounted for just over half of global meteorological coal exports at 52%. Globally, we've also doubled our liquefied natural gas export capacity in the 5 years prior to 2020. And our NDC says nothing about reducing our fossil fuel exports. Since May 2022, the federal environment ministers approved 11 new mines or mine expansions that together have 1,600 million tonnes of lifetime emissions. And there's 29 additional coal projects for newer expanded coal mines currently waiting for federal government approval, as well as a number of gas projects. People probably heard about the Northwest Shelf project. The Minister for the Environment, Murray Watt, made a decision to approve that immediately after our federal election. This is the climate bomb that would release, 4 billion tonnes of climate pollution over its lifetime. So it'd be 10 times Australia's domestic emissions, 10 years worth of Australia's domestic emissions from the Scope 3 emissions from this project. And the Australian government's constantly hiding behind the argument that these exported emissions are not our responsibility, that they're the responsibility of the countries that import them, that they need to address these emissions from when they burn the coal or the gas within their NDCs. And they use the argument that we only export to countries that are also part of the Paris Agreement, have made NDC commitments. But there's no reason why our NDC can't also include commitments about reducing the production of fossil fuels. And a lot of NGOs making the argument that they should. So the International Institute for Sustainable Development have sort of argued that this sort of third round of new NDCs is a timely opportunity for fossil fuel producing countries to include information and commitments relating to fossil fuel production. And some countries have taken up this opportunity. So the UK sort of said that it'll undertake consultation on halting new oil and gas licenses to explore new fields. Canada talks about ending new direct public support for international unabated fossil fuel energy sector. And two, this argument that we're not responsible for emissions that we export has really been knocked down by the ICJ advisory opinion, because the court said that where the emissions occur is not relevant. It concluded that nation states have an international law obligation to regulate private entities operating within their jurisdiction or control to ensure that they do not cause significant harm to the climate system, regardless of where the emissions causing that climate harm occur. And the ICJ specifically identified fossil fuel production and the granting of new fossil fuel production or exploration licenses as a potentially internationally wrongful act based on their harm to the climate system. So this really is the elephant in the room that the Australian government doesn't want to, but desperately needs to take action on.
Thank you both. That is extremely helpful. And also for the benefit perhaps of our readers who are not, or listeners, excuse me, who are not Australians, even if the 1% number is real, which as you both said, it's not, Australia's population is 26 million people, right? To be responsible for 1%, let alone 4.5, it is still many a time more than Australians' share of the global population, right? This is a small country in
We're high achievers. Yeah.
Yes, absolutely. Um, okay, so one of the, as you both explained beautifully, one of the, small print is the exclusion of the Scope 3 emissions. Another aspect of the, perhaps not small print, but makes things much more complicated, is that this plan seems to rely very heavily on carbon offsets, right? So rather than actually reducing emissions, doing other stuff that purportedly is going to balance out said emissions. So first, I wanted to ask, especially you guys, because you're the expert, if you can explain to us how do these carbon offsets work? And secondly, in the process of doing so, why does the climate movement express grave concerns about international carbon markets? Basically, are emissions reductions that are coming from carbon offsets real emissions reductions, or should we worry?
Yeah, so governments like Australia and a lot of corporations, frankly, love relying on these so-called carbon offsetting schemes as part of their calculations for meeting net zero targets. But the practice is really problematic. So essentially, the idea is already in itself a bit of a red flag. It's the logic is that a country or a corporation or an individual can continue to engage in activities that produce carbon emissions by burning fossil fuels or breeding and slaughtering huge populations of livestock, etc., while still claiming to reduce emissions by paying someone else to do stuff that reduces the total carbon emissions going into the atmosphere. And they include things like tree plantations, energy efficiency improvements, methane capture, soil sequestration, and forest conservation. Um, and to be fair, there is a small amount of logic in the kind of scheme, in that when we move towards a lower carbon or a low carbon economy, it's hard for many of us to completely avoid creating carbon emissions in that transition period. And it sometimes might be more realistic or efficient, at least, to temporarily make these lower hanging fruit savings elsewhere. But there are actually a lot of downsides to the approach that has been institutionalized. So first, they're more often being used to justify continuing business as usual rather than being used as this sort of transitionary temporary measure, meaning that its main contribution has actually been to delay the urgently needed decarbonisation of the economy. And for evidence, you just need to note all of the approvals that Julia was listing earlier, particularly including the Northwest Shelf Gas Project, which is a horrifying new development. And this came alongside the new shiny reductions targets. So it shows that incredible cognitive dissonance between the two kinds of concepts. Second, many of these offsetting projects actually have appalling human rights records, particularly when it comes to the displacement of local communities, often Indigenous communities. But I'll let Julia speak more to that because she's literally written a book about it. And then finally, over time, evidence has shown that the claimed offsetting or savings created by these projects is often significantly overstated. And this has started to play out in court in a number of jurisdictions, including in Australia. So earlier this year, the parties in Parents for Climate and Energy Australia settled. And the statement made by Energy Australia in the settlement was quite significant. So the facts of the case were that Parents for Climate had alleged that Energy Australia's marketing of what it called its Go Neutral carbon offsetting product was misleading or deceptive under Section 18 of the Australian Consumer Law. Essentially, consumers purchased this product and their electricity or gas was still predominantly provided through fossil fuel burning. But some money from their fees would also go into paying carbon offsets. And the marketing of this arrangement as neutral, i.e., carbon neutral, was challenged by Parents for Climate. And after 2 years of litigation, the parties reached a settlement under which Energy Australia acknowledged that offsets do not prevent or undo the harms caused by burning fossil fuels, pretty much knocking the legs out of the whole idea, really, of carbon offsettings being a valid way of making these calculations. And it really gets to the heart of this narrative that we can solve the climate crisis through the market, and that we can undo the damage if we just buy more things and keep going through this like consumption process. It's actually a symptom of market logic. It stems from that exact system. And so we need to move away from this endless growth on a finite planet through transformation. And carbon offsets are at best a distraction. And then at worst, they have all of these massive downsides. In that case, because it was settled, we don't have a judgment, which is a bit of a downside in terms of, precedent. But a recent case actually occurred in Germany against Apple, and this went to court, and the plaintiffs won. So here were the applicants. So it was German Environmental Aid, which in German is acronymed DUH, and they won a lawsuit in the Frankfurt Regional Court that ruled that Apple can no longer advertise its watches as CO2 neutral. So just like Energy Australia, Apple had been relying on offsets. In this case, they were using short-term eucalypt monoculture projects in Paraguay. And they were using them to justify the claims that the watches were carbon neutral. And the court found that this was misleading, as they cannot guarantee long-term carbon storage. The DUH had argued that these plantations are actually ecologically unsound, really water intensive, pesticide dependent, and they're just essentially unsuitable for climate offsetting. But this is a system that has grown up massively in this kind of idea that, oh, now that we've got like climate change, we can just start making money from that too. And it's just the absolute wrong direction. I'll let Julia elaborate though.
Thank you. Yes, Julia, if you want to talk a bit more, especially about the effects on the ground.
Yeah, sure. So, having written like a book and a PhD thesis on the problems of international carbon offsetting, I'm very happy. Even though, in some ways, as you often do after you write a book and PhD thesis, you try not to engage with the topic too much subsequently anymore. As Christy said, so many of these offset schemes have in so many questions around their environmental integrity. These questions around whether the emissions that are supposed to be stored through, growing trees or protecting forests, whether they're actually permanent. When we know that there's, climate change is leading to increased bushfires, etc. Whether these are actually additional reductions, what compared to what would have happened otherwise. You're dealing with these sort of ideas of speculative futures. And then, of course, the human rights questions. With international forest carbon offsets and REDD schemes, for example, there are a lot of concerns that there's 1.6 billion people internationally who rely on forest to some degree for their livelihood, 200 million of whom identify as Indigenous, and a lot of concern that by sort of making these sort of valuable as carbon sinks, that it leads to this sort of model of fortress conservation where people become excluded from the areas that they've looked after, protected the biodiversity of, and rely upon for their livelihoods as well as for culture and things. So there's so many concerns about the problems of offsets, international offsets. So I was pleased to read in the NDC that Australia has no plans or policies to use internationally transferred mitigation outcomes. So that's the carbon trading mechanism under Article 6 of the Paris Agreement as part of achieving its domestic emission reductions. So I think that's very positive. But I think what we really need to watch is the extent to which domestic offsets are going to be used as part of this. So Australia also has a domestic offsetting scheme where the credits are called Australian Carbon Credit Units or ACCUs. But also more broadly, the way in which a whole bunch of accounting tricks are being used to really rely upon the land use and land use sector to overrepresent what the government is actually doing. And so some of the really important work on this has sort of come from the Australia Institute, and Polly Hemming there in particular has really accused the government of cooking the books and thereby cooking the planet on this. And it really getting to the heart of a lot of this is really embedded in quite technical details that can be quite difficult to understand or to really piece out, and often quite difficult to explain to people because it's often about how you sort of set baselines against which you measure reductions, for example. So she shows that, most of the current reduction from 2005 levels of 25% under the current NDC has really been concentrated just in our land use sector rather than, a much broader social transformation away from fossil fuel dependency, which is what we urgently need to do. And she talks about how there's been a number of deliberate policy choices, including, the fact that our baseline year is 2005, that we measure our reductions against. So in 2005, emissions in the land sector were really unusually high due to extensive land clearing that year. And they were already trending downwards, not because of any particular policy choices, but just because they were. And then in 2010, heavy rainfall increased forest regrowth, and then that sort of pushed emissions lower. So then if you choose an inflated baseline, it looks like you're doing much more than you are just because of that choice of baseline already. And I think the thing to really be wary of is that any that the land use sector is key for climate action. We know that, 10 to 20% of emissions come from, the land use sector, but it's also so much volatility and variability there. If we just think about the devastating Black Summer bushfires of 2019 to 2020, where you had so many emissions that weren't considered as part of Australia's carbon accounting because they're not anthropocentric. They're because of natural disturbances that are seen to just sort of smooth themselves over. So there's lots of questions about those specific methodologies of how those things are counted. So if we exclude the land sector, rather than having reduced our emissions by 27%, we've only dropped them 3%. And that shows just how significant that is. And I think that's sort of the real question that we need to ask about this NDC, like how much of this 62 to 70% will come from, land sector and sort of manipulated baselines, etc., in the land sector rather than actually reducing our fossil fuel dependencies. There's a lot of integrity questions about domestic offsets. And now we're seeing the government really heavily investing in the idea of blue carbon. So rather than just the land sector, but focusing also on carbon that can be stored in aquatic ecosystems such as mangroves, salt marshes, and seagrasses. And we're already including coastal wetlands in our national accounting under the Paris Agreement, one of the few countries that's doing that. And so, just to sort of clarify, this ecological protection and restoration of these ecosystems is crucial. It has to be part of climate action, and it has so many other co-benefits for biodiversity, for culture, etc. But we can't be using the idea that we're protecting forests or wetlands as a substitute to reducing fossil fuel dependency or as a screen to shield scrutiny from the really necessary urgent work of transforming our energy systems. And indeed, the ICJ advisory opinion sort of suggests that this sort of work of ecological restoration should be understood as a crucial part of the restitution that's owed for a history of causing climate harm. And it can't be used as sort of a greenwashing tool to delay the urgently necessary mitigation that we need to see right now.
Fantastic. Yes, thank you, Julian. Thank you for bringing the discussion back to the ICJ in international law, right? Because I think if one reads the advisory opinion, especially as a whole, the court doesn't preclude the use of offsets, but also it puts so much emphasis on cutting our addiction to fossil fuels, right? That at the end of the day, the bulk of the action has to come from reducing real emissions that come from our dependence on fossil fuels. And on that note, I'm actually going to bring us a little bit back to a point we discussed a little bit earlier, which is basically the ICJ, but also other international courts and tribunals have also affirmed that general public international law, as well as human rights law, including the right to clean, healthy, and sustainable environment, continue to apply alongside specialized climate treaties in determining states' obligations in light of the worsening climate meltdown. And of course, and many have already talked about it, this is extremely important from the perspective of international adjudication. So if, especially some of our Pacific neighbors that are suffering from climate change ever want to bring an international case, the ICJ has left the door, wide open for it. But I was wondering if there is anything there for people in Australia, right? In other words, are there ways for the climate movement domestically to mobilize international law or international human rights law to challenge these problems that you have just outlined with the plan and to demand more ambitious climate action by Australia?
Yeah, so some of the most obvious avenues, though, include human rights law, but also environment and planning law. And I guess even sort of beyond the technically legal, political pressure, which is, so sort of a mechanism of creating law from below in many respects. So for international listeners, Australia doesn't have a Commonwealth, a National Human Rights Act. We're weirdos. but we do have three. We have one in the Australian Capital Territory, one in Victoria, and one in Queensland. And all of these explicitly draw from international human rights law. They reflect some main treaties in their wording, but they also sort of indicate that the interpretation should be guided by developments in international law. They're not frozen in time. And so all of these things can continue to be relevant to the way that they continue to evolve and are interpreted. And this creates a number of opportunities to push for more ambitious and more equitable climate action, particularly in these jurisdictions. So the ACT is sort of the most obvious because last year it amended the Human Rights Act to actually include the right to a healthy environment. Although it has a sort of a temporary, at least, or for the time being, it's not possible to litigate this particular right under the Act. It can only be enforced through a complaints mechanism or alongside other rights at the moment. There's also the fact that the ACT, I don't know how familiar people are with Canberra, but it's not a hotbed of development. So there's sort of some limited application. There's some limited scope in relation to Canberra. We don't have any mines or anything of that nature, but it will start to affect things like planning processes and built development.
And maybe at some point, Canberra should get a real public transport system. So there is a lot to be done as a former part-time Canberran. Perhaps
Yes.
like having actual public transport could help a little bit with the climate.
Very ambitious, Tina. So yes,
The
there are some
highest
definitely
standard of ambition.
there's some really significant local things that I think will come from this right. But in terms of Australia's main fossil fuel addiction problem, it's not going to be the centre of action. Nonetheless, all three jurisdictions protect the right to privacy in the home, the right to life, the rights of the child, and the cultural rights of Aboriginal and Torres Strait Islander peoples. And so that's been recognised in domestic litigation in the Waratah coal case, which was in Queensland, and also sort of been articulated in terms of why they are significant to climate action in international communication in the Daniel Billy and Australia communication. And it's very clear that these rights are being adversely affected by climate change. So the Waratah coal case is interesting too, because while it did rely on all of these rights under the Queensland Human Rights Act, and it did articulate that approving a new coal mine would exacerbate climate change and would therefore have these impacts, not just locally, but on communities quite far away that we're talking about, actually, the sort of transboundary impacts of the impact of this mine. It was also in the land court. So it was, in fact, a sort of a planning and environment decision ultimately. And even without a Human Rights Act, the New South Wales Land and Environment Court have a developing track record of using international law to interpret New South Wales environment and planning law. A lot of this has been focused particularly on the Paris Agreement. So cases like Gloucester Resources and the Minister of Planning and the Bushfire Survivors for Climate Action case against the Environmental Protection Authority. But there's been a really strong focus on the social impacts, for example, in the first one on the proposed Rocky Hill coal mine project, and in the second one on the New South Wales Environmental Protection Authority's just complete failure to really incorporate climate change into its planning instruments. And so this focus on the social impacts and looking at kind of the Paris Agreement's bringing in of human rights into the agreement itself then starts to open up avenues, I think, for litigation to draw on what that means in international human rights law and how that should be interpreted kind of, through the same approach that the RCJ showed, which is none of these things can be disentangled. They're all relevant to each other. And I think they have a real openness to considering emerging human rights law. Of course, the Chief Judge of the New South Wales Land and Environment Court is Justice Preston, and many people have probably seen him speak internationally on these issues. He's a really sharp mind, but he's also really committed to these issues. And so that's one of the reasons why the court has really led the way in Australia. Finally, I don't see a lot of hope right now in actions in tort, in negligence. So the outcomes of both the Sharma case and now the Pabbo case seem for now to have really closed off this option, although notably in the Pabbo judgment, there was a clear call for this to be appealed and for this to be reconsidered. There was a frustration on the part of the judge, quite evidently, that he was not in a position to take this, to sort of move this law forward. So bolder people than I may push on that front, but I'm not a torts lawyer. Nonetheless, I do think that these international human rights law developments and the ICJ's advisory opinion and people's attention to this issue can actually be really used in advocacy and law reform activities, and that we might just start to see these little sort of hooks. There's even recent New South Wales law that has recognised the right to a healthy environment. They were very keen to say they were first before the ACT, just in terms of interpretive provisions. And so a lot of drafters of legislation are kind of just like incorporating them in terms of how things should be interpreted. And we are increasingly seeing litigation that makes use of that, those angles. And I understand Australia has like the second most climate litigation in the world. Like, we are very keen to litigate this as citizens. We're aware of the ridiculous role that we play internationally in driving the climate crisis. And so I'm hoping that some of those international developments start to feed into the action that's already taking place.
Thanks, Cristy. And again, perhaps for the non-Australian listeners, right? Polls show consistently that Australians, want more climate action, right? It's just the political system is such, and also the electoral system is such, that it's actually really hard to make this happen through electoral politics, basically. So I think that could perhaps explain why Australians are such high achievers in climate litigation. Julia?
Yeah, so just again, want to endorse everything that's already been said, and just again to do a shout out too for all the amazing climate litigators in Australia. I think there's such creativity as well, that Australia has really been leading the way in trialing novel causes of action, about different ways of sort of getting at some of these problems, or thinking about how you could utilize the law in really novel and innovative ways as well. So there's a lot to watch in this space. In addition to what's been said, I really think a really important case to watch at the moment is Whitehaven Coal and Australian Conservation Foundation. That was heard in the Queensland Land Court recently, and the judgment's still pending. So it's the first Australian case sort of regarding coal extraction that was heard since the ICJ handed down the advisory opinion. And I feel bad for the poor advocates in that case. You have to sort of scramble and prepare additional submissions at the last minute to take into account the impact of the decision. I think it was in the same week that they were in court as the ICJ case. But this case concerns Whitehaven's proposed Winchester South mine, which is currently seeking approval to proceed in the Northern Bowen Basin in central Queensland. That would be a mine would be ongoing for 35 years. Open cut mine would produce approximately 15 million tonnes of predominantly steel making coal for export. But like, even by Queensland standards, and they have big mines in Queensland, this is a very big mine. And the case has then sort of really engaged arguments about the relevance of the ICJ advisory opinion for domestic Australian law. Because as part of its discussion, the ICJ elaborated on the duty that states have under the no harm rule to avoid harm to the environment. And that part of those duties is to assess the climate related impacts as part of environmental assessment level at the level of the proposed project. And then as part of the assessment of a new coal mine, for example, you need to engage with an assessment of the cumulative and diffuse nature of greenhouse gas emissions and to assess that risk. And so, based on the ICJ ruling, an environmental impact assessment process should not only assess the impacts on a particular project in isolation, but also assess the impacts of that project in the context of all other activities within the state's jurisdictions, and arguably within the context of cumulative emissions globally, which hopefully will help, because often the courts have sort of tried to rely on this argument, or project proponents have tried to rely on this argument that this is just a drop in the bucket. Whereas if you look at the drop in the bucket in the context of a very overflowing bucket, then it becomes much more significant. And the case is also advancing similar human rights arguments to what was made in the Waratah Coal case, so bringing the Queensland Human Rights Act. But in doing so, I think can also bring in some of the jurisprudence from the advisory opinion about right to a healthy environment, about the relationship between climate change and all other human rights. And so I think, yeah, so that will be a really interesting case to watch to see what the Queensland Land Court does with that. On Waratah, I was just very excited to see this last week that after the Waratah decision, which, as Christy said, was a really significant environment human rights decision, it was actually contested in investor state dispute resolution. Clive Palmer, the mine's owner, his 100% Singapore-based company, Sephora Investments, then took an action against Australia, three different actions under different trade agreements. But in an unrelated action about iron ore in Western Australia, the tribunal last week found that he wasn't actually a foreign investor. So hopefully that has a positive flow-on effect for these ISDS cases around the Waratah coal mine process. And then finally, I think there's a lot of work that needs to be done, sort of trying to bring human rights accountability to bear on Australia's exported emissions. The Australian Climate Accountability Project has recently published a great report with detailed legal analysis of how our exported emissions are in breach of international human rights obligations. But the challenge is really finding a forum or a hook for making these arguments domestically because we have so few human rights mechanisms in Australia.
Yeah, fantastic. So, what I heard basically from both of you was that even though the Australian domestic legal system perhaps is not the most friendly to international law and international human rights law, there has nevertheless been signs that, courts and tribunals are willing to give weight to international law, especially when interpreting domestic legislation, right? Okay, on that note, I think I'm slowly going to bring us to the end. My final question, especially because we're discussing climate, and anyone who works on climate would know, or anyone who listen to the news would know that climate grief is real, and there's so many other reasons to grieve if one pays attention. My question was basically, which again, we ask a lot of our participants, what do you do to unwind and take your mind away from climate meltdown and fossil fuel addiction? Christy?
Yeah, so the first thing I do is like diving in rather than coming out. But I have a podcast with my friend and colleague Elizabeth McPherson. It's called Law at the End of the World. And I guess we're very focused on sort of transformation space. And I guess it gives me hope, which is another way of dealing with the grief. I also do most of my research collaboratively, and I do find that working with others and getting, hope from them when they're on and up and I'm not so much can just provide those needed moments of solidarity and hope in this space that otherwise can become a little bleak. But less nerdily, I just really like walking, preferably along rivers. And I do find that just going for a walk is probably the best thing that I can do. I always try to remember to myself, even if the weather's not so ideal, you never feel worse after a walk. It's always a good way of just getting some headspace and getting a little bit away from screens and doom scrolling. So I walk.
That sounds like a good idea. Thank you, Christy. Julia?
Yeah, thanks so much for this question. I think the climate grief is very real, particularly at the moment when it's compounded with the grief of watching a ongoing live stream genocide. And I think realizing how these things are connected, that it's an ecocide alongside a genocide that we're witnessing, and that part just sort of, yeah, it becomes overwhelming at times. Some things that I've been doing is I started a painting or drawing art course earlier this year, and that's 1 day a week, and I really love it. I love having that chance to, again, get away from the screen, be really focused on something and be really challenging myself to do something different and to do things that I didn't think I could do. I've also recently taken up meditation and try and sit for 20 minutes at the beginning of each day. And I'm actually quite amazed because I've always been terrible at being consistent with anything, and how helpful having a consistent practice is and how it does really impact on your day-to-day mood and your engagement with the world. And then finally, I'd completely echo what's been said about going for walks and going on hikes. I find nothing more restorative than getting into nature, even if it is just, the Merri Creek in Coburg, but ideally, getting further out into the bush and just having that immersion in that sort of space of an ecosystem is, I find, incredibly restorative.
Thank you both. I think you inspired me. I'm going to finish the recording and go for a walk. Thank you both for your wisdom and your knowledge, and thanks to everyone for listening.